Hi, everyone. I'm really pleased that you decided to join me to take a look at U.S. history. We try to take a look at U.S. history from a variety of different angles, try to identify the story behind the story. Sometimes we try to look at the odd things that have happened, and certainly examine the personalities that have made the American experience so unique in all the history of the world. In particular, we take a look at the U.S. Constitution, this wonderful document that has governed this country for well over 200 years. And we try to understand some of the complications and some of the problems that we face as a nation, day by day, year by year, month by month. In any event, I hope you're enjoying this and that you come back often because I will keep repeating these and posting them to YouTube so that you can relive the experience if you want to do it more than once. And I hope you do. Anyway, welcome and enjoy the presentations. Before we really get started, I have a favor to ask. If you would go down below and you would hit the subscribe and the like buttons, then that would give me an incentive to produce even more of these history programs just for you. So today, the subject is going to be because it's Black History Month. And so we're going to take a look at what some people could call America's original sin that started in 1619 when the first African Americans are said to have arrived in Jamestown up until the modern day. Now, this is such a big topic, it's going to take 2 sessions to cover it all, but we'll get as far as we can today. So we're going to begin a little bit. We're going to skip a lot of the early stuff from 1619 to 1865, but we're going to talk about how the struggle for civil rights really begins with the end of the Civil War. And then we certainly have to discuss the role of the courts because they played a pivotal role all the way through and they still do. And we'll talk about some of the changes that are still underway or were in 18 from up through 1965 and how the movement finally made a huge difference. So the struggle begins, and there was some post-Civil War legislation. We'll talk about the magnificent Harlem Renaissance, World War II and its major impact. We'll have to mention CORE, the Congress of Racial Equality, the famous case Brown versus the Board of Education, and some of the things that happened in the 1940s. So post-Civil War legislation. The first big one was the 13th Amendment, which freed the slaves. And then 3 years later, the 14th Amendment, which provides for equal protection under the law. The 15th Amendment, the third of the civil rights movements, or amendments rather, came about in 1870, which provided universal male suffrage regardless of your color. In the 1883 civil rights cases, established a narrow interpretation of the 14th Amendment and allowed racial discrimination as long as it was outside of the regulation of the federal government. Famous case of Plessy versus Ferguson in 1896, which established, at least for a long time, separate but equal, where facilities were allowed, and it legalized segregation. From the 1890s to the 1950s, we have a lot of Jim Crow laws mandating segregation and preventing blacks from voting. How about these Jim Crow laws? After Reconstruction, many Southern state governments passed what we refer to as Jim Crow laws, forcing separation of the races in public places. Here are some examples of Jim Crow laws. Lunch counters, where it said that no person, firms, or corporations who or which furnish meals to passengers at station restaurants or station eating houses will allow and will skip to white and colored passengers in the same room or at the same table or at the same counter. This was in South Carolina. The books shall not be interchangeable between white and colored schools, but continue to be used by the race first using them. The whites didn't want the contaminated books that blacks had touched. The prisons, the warden shall see that the white convicts have separate apartments for both eating and sleeping from the Negro convicts. Some more examples. In the parks, it shall be unlawful for colored people to frequent any park owned or maintained by the city for the benefit, use, and enjoyment of white persons, and unlawful for any white person to frequent any park owned or maintained by the city for the use and benefit of colored persons. In burial, even. The officer in charge shall not bury, nor allow to be buried any colored persons upon grounds set apart for the use of the burial of white persons. That's in Georgia. Nurses, no person or corporation shall require any white female nurse to nurse in wards, or rooms in hospitals, either public or private, in which Negro men are placed. Intermarriage, all marriages of white persons with Negroes, mulattoes, Mongolians, or Malayas, hereafter contracted in the state of Wyoming, are and shall be illegal and void. Even way out in Wyoming, they had Jim Crow laws. And so we have in 1832, Thomas D. Rice wrote a song entitled Jim Crow, which is where the term originated. I want to warn you, this song contains the N word, and it is sung in its
Jim
original
Crow,
form.
sung by sheet music singer. I come from old Kentucky a long time ago, where I first learned to wheel about and jump Jim Crow. Wheel about and turn about and do just so. Every time I wheel about, I jump Jim Crow. I used to take him fiddle every morning and afternoon, and charm the old buzzard and dance to the raccoon. Wheel about and turn about and do just so. Every time I wheel about, I jump Jim Crow. I whip my weight in wildcats, I need an alligator, and tear up more ground and cover 50 load of tater. Wheel about and turn about and do just so. Every time I wheel about, I jump Jim Crow.
Song was the beginning of the term Jim Crow. So let's talk about the 14th Amendment, which I would advance, other than the First and Second Amendment, is the most important amendment to the Constitution. First of all, it essentially reverses Dred Scott ruling from 1857. The Dred Scott ruling essentially said that black people could never be people. They could be property, but they could never be people. And this reverses that. July 8th, 1868, Louisiana and South Carolina voted to ratify the amendment after they'd rejected it a year earlier, and it made it the 14th Amendment to the Constitution. But, and this is a big but, in the ensuing years, the Supreme Court was slow to decide how the new and old rights guaranteed under the federal Constitution applied to the states. In the early Supreme Court decisions, the court limited the incorporation of these rights on a state and local level. But starting in the 1920s, the court embraced the application of due process and equal protection despite state laws that conflicted with the 14th Amendment. Intimidation and crimes were directed against African Americans, and we have the phenomenon of lynchings, which is so terrible that I can't even describe how awful it would be. Lynchings, illegally executions, usually by hanging. African Americans look to the U.S. courts to protect their rights. So here are some pictures of segregated facilities that note the separate water fountains and the separate waiting rooms and even inferior water fountains. And I saw these when I traveled through the South in the 1960s. So it was not something in ancient history that these occurred. And it also affected later Spanish and Mexicans who were discriminated against also. The slaughterhouse cases. In 1873, the slaughterhouse cases limited the scope of the privileges or immunities clause of the 14th Amendment. It protects only federal, not state citizenship rights. This is how the Supreme Court interpreted the 14th Amendment. It said that it did not apply to any state law or any local law, but only when a federal law was being violated. It minimized this impact on state law. In 2010, it took till 2010, the court rejected arguments to overrule the established precedent of slaughterhouse and decided instead to incorporate the Second Amendment by the due process clause of the 14th Amendment. It was a big change, but it took all the way from 1873 until 2010 for that to change. So what kind of segregation can there be? There can be what is called de jure segregation. That is segregation by law. It's common in the South, especially during the Jim Crow era. The laws forbid African Americans from attending the same church, using the same swimming pool, eating in restaurants, or marrying white people. But then more awesome, or awful rather, is de facto segregation. That is segregation without laws. Common in the North. You see, it wasn't only the South. There was housing discrimination, which made segregation in the North. The white community groups did not allow non-whites to live in white neighborhoods. Every ethnic group had its own part of town. And unfortunately, we still have a lot of de facto segregation in this country. So what techniques did the civil rights leaders use? Well, many of them were influenced by the ideas of Mohandas Gandhi, which was nonviolent protests, boycotts, in other words. Also influenced by the ideas of Henry Thoreau, where civil disobedience, the sit-ins that became part of that response. And most importantly, probably, is the law, legal action. Oliver Whitehill Sr. was an American civil rights attorney from Richmond, Virginia, and his work against racial discrimination helped the doctrine of separate, end this doctrine of separate but equal. Civil Rights Act of 1875 was called the last of the major Reconstruction statutes, which guaranteed African Americans equal treatment in public transportation and public accommodation and service on juries. March 1, 1875, the Civil Rights Act affirmed the equality of all men before the law and prohibited racial discrimination in public places and facilities, such as restaurants and public transportation. The law also made it a crime for anyone to facilitate the denial of such accommodation or services on the basis of color, race, or previous condition of servitude. This was a good law. It was headed in the right direction. All lawsuits arising under the Civil Rights Act were to be tried in federal courts rather than at the state level, although the act was seldom enforced. While few observers expected the legislation to change the prevailing racial attitudes of both Northern and Southern whites, the law aimed to protect African Americans from deprivation of the minimal rights of citizenship. The act was designed to protect all citizens in their civil and legal rights, providing for equal treatment in public accommodation and public transportation and prohibiting exclusion from jury service. Originally drafted by Senator Charles Sumner in 1870, wasn't passed until after he passed away in 1875. This was one of the great men of the U.S. Senate and of all of U.S. history, Charles Sumner. The law was not effectively enforced, in part because President Grant favored different measures to help him suppress election-related violence against blacks and Republicans in the South. The Reconstruction era ended with the resolution of the 1876 presidential election. The Civil Rights Act of 1875 was the last federal civil rights law enacted until the passage of the Civil Rights Act of 1957. That's a long gap. In 1883, as I've already mentioned, the Supreme Court ruled in the civil rights cases that the public accommodation sections of the Act were unconstitutional, saying that Congress was not afforded control over private persons or corporations under the Equal Protection Clause. Parts of the Civil Rights Act of 1875 were later readopted in the Civil Rights Act of 1964 and the Civil Rights Act of 1968, both of which cited the Commerce Clause as the source of Congress's power to regulate private actors. Then we have civil rights nullification in 1883, which I mentioned. And that was an 8-1 ruling in the civil rights cases that neither the 13th Amendment, which banned slavery, nor the 14th Amendment, which guaranteed equal protection of the law to African Americans, was infringed by the existence of uncodified racial discrimination, which therefore could not be constitutionally prohibited. The decision nullified the Civil Rights Act and in effect robbed the two amendments, the 13th and 14th, of their meaning rather. The ruling would remain in force until the court disavowed it, upholding the Civil Rights Act of 1964, 100 years after the Civil War ended. Then other discrimination. The Chinese Exclusion Act of 1882 was the first significant law restricting immigration into the United States. Many Americans on the West Coast attributed declining wages and economic ills to the Chinese workers. Although the Chinese composed only 0.002% of the nation's population, Congress passed the Exclusion Act to placate worker demands and assuage prevalent concerns about maintaining white racial purity. The Exclusion Act of 1852 came because of an 1852 crop failure in China. At that time, over 20,000 Chinese immigrants came through San Francisco's Custom House, which was a dramatic increase up from 2,716 the previous year, looking for work. Violence soon broke out between white miners and the new arrivals, much of it racially charged. In May of 1852, California imposed a foreign miners tax of $3 a month, meant to target Chinese miners, and crime and violence escalated. In 1854, a Supreme Court case, People versus Hall, ruled that the Chinese, like African Americans and Native Americans, were not allowed to testify in court, making it impossible for Chinese immigrants to seek justice against the violence. By 1870, Chinese miners had paid $5 million to the state of California via the foreign miners tax, yet they faced continued discrimination at work and in their camps. The Geary Act. This went into effect on May 5th, 1892. It reinforced and extended the Chinese Exclusion Act's ban on Chinese immigration for an additional 10 years. It also required Chinese residents to carry special documentation, certificates of residence, from the Internal Revenue Service. The Supreme Court upheld the Geary Act in the Fong Yuting versus the United States in 1893. And in 1902, Chinese immigration was made permanently illegal. The legislation proved very effective, and the Chinese population in the United States sharply declined. Plessy versus Ferguson. 1896's Plessy versus Ferguson, the Supreme Court ruled that separate but equal did not violate the 14th Amendment, upholding the Jim Crow laws of the era. Facilities were separate, but they were never equal. Here's a great cartoon that shows the beautiful Roman-type water fountain for those who are white and the primitive pump for those that are black. Separate, but not equal. So some facts. In 1896, Homer Plessy took a seat in the whites-only car of a train, this is in Louisiana, and refused to move. He was arrested, tried, and convicted in the District Court of New Orleans for breaking Louisiana's segregation law. Was the Louisiana law separating blacks and whites on railroad cars legal? Split decision came from the Supreme Court that separate but equal did not violate the 14th Amendment. And what made this all ironic was that Plessy himself was 7/8 white. Even a little bit of black made you. Very famous case, Lochner versus New York. Lochner, a baker from New York, was convicted of violating the New York Bake Shop Act, which prohibited bakers from working more than 10 hours a day and 60 hours a week. The Supreme Court struck down the Bake Shop Act, however, ruling that it infringed on Lochner's right to contract. The court extracted this right from the Due Process Clause of the 14th Amendment, a move that many believed exceeded judicial authority. This was one of the terrible rulings of the U.S. Supreme Court. Our great Supreme Court can and does often make mistakes, and this was one of the great ones. The 1917 Immigration Act. In 1917, the U.S. Congress enacted the first widely restrictive immigration law. The uncertainty generated over national security during World War I made it possible for Congress to pass this legislation, and it included several important provisions that paved the way for the 1924 Act. The 1917 Act implemented a literacy test that required immigrants over 16 years old to demonstrate basic reading comprehension in any language. It increased the tax paid by new immigrants upon arrival and allowed immigration officials to exercise more discretion over whom to exclude. Finally, the act excluded from entry anyone born in a geographically defined Asiatic barred zone, except for Japanese and Filipinos. Why those two are exempted? In 1907, the Japanese government had voluntarily limited Japanese immigration to the United States in the Gentleman's Agreement. The Philippines was at that time, had been at least, was a U.S. colony, so its citizens were U.S. nationals and could travel freely to the United States. China was not included in the barred zone, but the Chinese were already denied immigration visas under the Chinese Exclusion Act. We were not nice. The Immigration Act of 1924, this limited the number of immigrants allowed entry into the United States through a national origins quota. The quota provided immigration visas to 2% of the total number of people of each nationality in the United States as of the 1890 national census. And this was later amended to 1920 and then another time in 1930. But who were 2% of the population in those early days? It was the English, it was the Germans, it was the French, it was the Norwegians, it was the Swedes, it was the Danes, it was the people of Northern and Western Europe. It completely excluded immigrants from all the other countries of Asia. Then the case of Gitlow versus New York. Before 1925, the Bill of Rights was usually only applied only to federal government actions, as I've already noted. Gitlow started an application to the state's actions. A socialist named Benjamin Gitlow printed an article advocating the forceful overthrow of the government. He was arrested under New York state law. He argued that the First Amendment guaranteed freedom of speech and of the press. On appeal, the Supreme Court said that the First Amendment applied to New York through the Due Process Clause of the 14th Amendment. So that was good. However, the court ultimately ruled that Gitlow's speech was not protected under the First Amendment by applying the, quote, clear and present danger, close quote, test. The court's ruling was the first of many instances beginning to incorporate the Bill of Rights. Schenck versus the United States in 1919. The primary holding was that if speech is intended to result in a crime, and if there is a clear and present danger, and that's the important phrase, that it actually will result in a crime, the First Amendment does not protect the speaker from government action. Oliver Wendell Holmes said, the First Amendment does not allow people to shout fire in a crowded theater. Facts, during the First World War, the federal government imposed conscription into the armed services. Opposing the draft, the Socialist Party in Philadelphia authorized General Secretary Charles Schenck to print and distribute 15,000 leaflets to the public. That the 13th Amendment prohibition against involuntary servitude meant that the draft was unconstitutional and should not be obeyed. Not long before, however, Congress had passed the Espionage Act of 1917 to forbid conduct undermining the war effort. Schenck was convicted of violating this law and appealed on the grounds that the statute violated the text of the First Amendment. Great migration needs to be mentioned. During the late 19th and early 20th century, African Americans began the Great Migration to northern cities in search of jobs and to escape poverty and discrimination in the South. Jim Crow laws were not popular in the North, but the migrants still suffered discrimination. And here's where they went. They left all of the states of the Old South, the old Confederacy, and they moved to the North, to Chicago and Detroit and Cleveland and New York and Philadelphia. to San Francisco and Seattle and Los Angeles and San Diego and any of the other cities of the North. Northern problems. African Americans faced racism and discrimination in the North, too. Confrontation with immigrant groups were a result of a competition for jobs. De facto, remember I talked about de facto segregation? It's not a law, but it's just the fact of things. Arose as African Americans settled in their own ethnic communities, which were known as ghettos. The National Association for the Advancement of Colored People comes on the scene in 1909. Founded in 1909 by Ida B. Wells, W.E.B. Du Bois, Henry Moskowitz, Mary White of Ovington, Oswald Garrison Villard, and William English Walling. Provided legal aid and other support for people who were being treated unfairly under the law. The strategy was to eradicate institutionalized racism and fulfill the 14th Amendment, which guaranteed equal treatment under the law. And here they are. This is W.E.B. Du Bois. This is Booker T. Washington and Ida B. Wells. They had disagreements over solving discrimination. Ida B. Wells led an anti-lynching crusade and called on the federal government to take action. She brought to our consciousness the fact that this lynching was taking place so frequently and was so unlawful. Congress failed to make a law preventing lynchings. However, Wells raised a great deal of public awareness about the horrors of lynching, and it was as horrible a thing as you could possibly imagine. Booker T. Washington, a pragmatist, and I call him a gradualist, and he did his greatest and most influential work in the 1890s. He believed that the way to racial equality was through vocational education and economic success. Vocational specific jobs should be trained. Accepted social separation. He said, oh, it's all right for us to stay separate from the whites as long as we get jobs. And then when we have jobs, we will gradually work our way towards equality. He believed that economic success would lead to social equality. But this guy, W.E.B. Du Bois, now it's important to note, he was an immediatist. He believed that segregation should end now. But it's important to note that his work was 15 years after Washington. And in 15 years, many things change in a society. He believed that education was meaningless without equality. Helped found the National Association for the Advancement of Colored People. And he's a very important person in the history of the Black movement. Harlem Renaissance, 1919 to 1935. This is post-World War I. Many blacks fled the South for better economic opportunities and freedom from KKK violence. Harlem was a popular destination, and New York's black population swelled from over 30,000 in 1900 to over 300,000 in 1930. Black artists, writers, dancers, poets, and so forth all found a chance to explore their creativity. And there were many, they did it in painting, they did it in sculpture, they did it in music, they did it in jazz, they did it in all of the art fields that you can imagine, and writing and in poetry and so forth. Preparation for World War II created millions of new jobs. However, due to discrimination, many blacks were prevented from getting jobs. This guy is very important in the history of the black movement, A. Philip Randolph. He was the leader of the Brotherhood of Sleeping Car Porters Union. And we don't think so much of the importance of that now, but in the early part of the 19th century, one of the most important jobs was to be a porter on a sleeping car. And it gave you a lot of power and influence, so to speak, and a decent living income. Randolph met with FDR to inform him that he was planning a massive march on the White House lawn if something was not changed. And so here's a poster advertising the proposed march in 1941. Why should we march? And he's talking about 15,000 in St. Louis and 20,000 in Chicago and 23,000 plus in New York City. Millions of Negro Americans all over this great land want to be free. As a result, FDR issues Executive Order 8802, June of 1941. So the march does not take place. The order required federal agencies and departments involved with defense and production to ensure that vocational and training programs were administered without discrimination as to race, creed, color, or national origin. All defense contracts were to include provisions that barred private contractors from discrimination as well. As a result of this order, black women made many important contributions to the war effort in World War II. They began to work in the factories in a way they had never done before. Historically, African Americans served in segregated units in every U.S. war. They were there in segregated units in the Civil War. They were there as segregated units in the Spanish-American War, and they were there in segregated units in World War I as well. World War II still had segregated troops, and they performed beautifully, marvelously. Important case is Korematsu versus the United States. 10 weeks after the U.S. entered World War II, President Roosevelt signed Executive Order 9066, ordering the Secretary of War and Armed Forces to remove people of Japanese ancestry and to intern them, in other words, to imprison them. Fred Korematsu was a Japanese American citizen who did not comply. He had plastic surgery in his eyes to alter his appearance, changed his name to Clyde Sarah, and said he was of Spanish and Hawaiian ancestry. He was arrested in 1942. The ACLU made his test case to challenge the constitutionality of the government's order. In 1944, and this is one of those, again, shameful, wrong things that the U.S. Supreme Court did. The Supreme Court ruled that his arrest and being interned were constitutional. So we cannot always depend on the U.S. Supreme Court. Another important case is Primus King versus the state of Georgia. July 4th, 1944, Primus E. King, an African-American registered voter, went to the Muskogee County Courthouse in Columbus to cast his vote in the Democratic Party's primary election. He was turned away by law enforcement and he filed a lawsuit. In a landmark ruling, the U.S. District Court found Mr. King in Mr. King's favor, deciding that the exclusion of black voters was unconstitutional under the three Civil Rights Amendments. The U.S. Court of Appeals affirmed, and the U.S. Supreme Court refused to hear the appeal. Remember, the Supreme Court only takes about 80 cases a year out of perhaps thousands that are filed. That ended the white primary in Georgia. Morgan versus Virginia in 1946. Irene Morgan refused to give up her seat. NAACP appealed her arrest for violating the segregation law. The Supreme Court struck down the Virginia law. Many state laws requiring segregation on buses illegal for interstate travel. Victory for civil rights. Though not directly addressing segregation, it paved the way for future challenges and marked an early win in the movement. These things come a little piece at a time, one victory on top of another victory on top of another victory, and there's still many victories that need to be won. Truman comes through after World War II is over, where he desegregates the military with Executive Order 9981 in 1948. President Truman wipes out segregation in the armed forces. Very controversial at the time, but clearly it was the right thing to do. Congress of Racial Equality, CORE, formed in 1942 by an interracial group of students in Chicago. Greatly influenced by Gandhi's nonviolent techniques, the purpose of the organization was to end racism through nonviolent strategies such as sit-ins, jail-ins, freedom rides. Brown versus the Board of Education, 1954. Following the court's ruling in 1896 of Plessy versus Ferguson, segregation of public schools based solely on race was allowed by states if the facilities were equal. Brown overturned that decision. Regardless of the equality of facilities, the court ruled that separate is inherently unequal. The public school segregation based on race was found in violation of the 14th Amendment's Equal Protection Clause. So there was a question of harm. You see, in law, you need to determine if something in factually does harm. And so they had to prove that there was harm in this segregation. And so these two people, education became the focus of the fight for equal treatment under the law. And it was headed, this important study was done by Kenneth and Mamie Clark in 1940, the genesis of racial identification and preferences for Negro children. It was a very credible academic study. Study was therefore cited as proof of the detrimental effects of segregation in the 1954 Brown versus the Board of Education. And here is the official paper that in fact goes to the Supreme Court and it's signed. I can see Thurgood Marshall's signature right there. Celebrating the Brown decision on May 17th, separate educational facilities are inherently unequal. Separating children solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to be undone. Chief Justice Earl Warren. And over on the left, you see the key lawyers who, in fact, did this case for segregation for the Brown versus the Board of Education. And you see Thurgood Marshall, who later is appointed to the Supreme Court, based on the reputation that he achieved in this case, partly at least on that basis. And I should note that Earl Warren had been governor of California, and Eisenhower appointed him as Chief Justice, and he was new on the court. And what he achieves is a unanimous decision, which was really, really remarkable for him to be able to do. And here is an important picture, a cartoon, if you would, that shows here lies Jim Crow, and it's a casket being carried on the street. The role of the Supreme Court in the civil rights movement. The Supreme Court is the safekeeper of the Constitution. It interprets the laws by making sure they fit in line with the Constitution. Judicial review is the power of the court to declare acts of Congress and the president unconstitutional. The Warren Court, which lasted from 53 to 69, played a major role in the civil rights movement by interpreting laws as contrary to constitutional principles. I'm not sure that they would be as effective today because the court's composition has changed. Important events in the 40s, June 1941, when FDR ordered an end to discrimination. 1942, CORE is formed. 1944, Primus King versus the state of Georgia. And so the whites only primary was unconstitutional. Morgan versus Virginia, the Supreme Court ruled that segregation on interstate buses was illegal. 1947, the first freedom rides in the North by CORE to test the new Supreme Court by banning segregation on buses. 1948, Shelley versus Kramer. Supreme Court ruled that a state court could not constitutionally restrict an American from occupying a property on the basis of race. This desegregated housing. 1948, Truman's 99-81 desegregated the military and other federal employment. Now, it needs to be said that while there was much progress made, we need to also remember there was then and there still is a lot of de facto segregation. If you were going to go up and down I-95 and go about 3/4 of a mile on either side, you would find that that it is disproportionately a black community even today here in Broward County. So we have the changes that are going to come about. We all know about Rosa Parks and Martin Luther King Jr. and the Montgomery bus boycott, Central High School, Little Rock. SNCC comes into existence, 1957 Civil Rights Act, and some important timeline cases. So why civil rights movement in the 1960s? Why did it take 100 years, before we finally began to get civil rights action? Reason number one was World War II and the Korean War. During World War II and the Korean War, racial minorities such as African Americans, Hispanics, or Native Americans had made many gains. The U.S. military had needed their help and had allowed them to fight. Many came as heroes and earned respect. During the Cold War, America was trying to convince the world that it was better than the Soviet Union, and racism made America look bad to the rest of the world. Communists could use America's racism as an example showing that the US was evil. With the arrival of television, Americans could watch the news every day. This television made such a difference in people's consciousness of what was happening. It was real instead of being abstract. The nonviolent civil disobedience used by King made the civil rights protesters look like good people and made the opponents look hateful, violent, and ugly, and they were. People could also hear Dr. King's inspiring speeches, and he had been given the gift of being able to speak in a way that touched the heart. He was a powerful speaker who knew how to change people's hearts and minds. Civil rights movement also, it was the world. Most people believed America had fought those wars for democracy and freedom. Racial segregation started to seem un-American to many. People remembered that Hitler and the other bad guys had been racist. Got to mention the Montgomery boycott, where Rosa Parks refused to give up her seat for a white man in 1955. African American citizens in many cities had for years complained bitterly about treatment on segregated city buses, and they needed the city buses because most of them could not afford cars. Earlier in 1955, a Sarah Mae Fleming had sued the city of Columbia, South Carolina, and that case was in the U.S. Fourth Circuit Court of Appeals, which ruled in the case that segregated seating was unconstitutional. After appeals and a third trial, the jury quickly found that bus company's favor. But by that time, the Montgomery bus boycott and the decision in Browder versus Gale had been rendered, and so a third appeal was not filed. 1955, man by the name of James M. Ritter refused a driver's order to move to the rear of a bus in Richmond, was fined $10. Other cases were very similar in this time. This sweet little girl. March 2nd, 1955, a teenager by the name of Claudette Colvin was arrested for violating the same segregation law that Mrs. Parks ran afoul of later that year on December 1, 1955. Colvin was the first person to plead not guilty to such a charge. Her attorney, Fred Gray, who would play a key role in overturning this in the Montgomery boycott case, raised constitutional issues in her defense, but she was convicted. Montgomery bus boycott. For years, Montgomery's black leaders did not publicize Colvin's pioneering effort. Colvin has said, young people think Rosa Parks just sat down on a bus and ended segregation, but that wasn't the case at all. Colvin's case was dropped by the civil rights campaigners because Colvin was unmarried and pregnant during the proceedings. Rosa Parks stated, if the white press got hold of that information, they would have had a field day. They'd call her a bad girl and her case wouldn't have had a chance. Colvin's record later on was expunged in 2021 from the charges that were brought more than 66 years before. African American residents of Montgomery, Alabama supported Rosa Parks' defiance and organized a one-day bus boycott. That was all it was supposed to be, is a one-day bus boycott. It was so successful that the Montgomery Improvement Association was formed to continue the boycott. The leader of the new organization was Martin Luther King Jr., and the boycott lasted 381 days. Now remember, Martin Luther King, when he moved to Montgomery, he was a nobody. Nobody. He wasn't a part of the black establishment at that point. Matter of fact, they turned to him because no one else would take the job. He said, and you know, my friends, there comes a time when people get tired of being trampled over by the iron feet of oppression. If we are wrong, the Supreme Court of the nation is wrong. He said that in 1955. As a result of the Brown 1954 decision, schools were to be integrated with all deliberate speed. Arkansas Governor Faubus openly defied the law and ordered the Arkansas National Guard to prevent African American students from enrolling at Central High. Eisenhower met with Faubus and believed that the African American students would be allowed to enroll. Faubus went back to Arkansas And when the students enrolled, the defiant Governor Faubus removed the National Guard, leading to violence. Eisenhower federalized the National Guard and sent U.S. Army units to restore order. And here are the 9 African American students who attended Central High School in this protest case in Little Rock, Arkansas. One of them has passed away, the rest are still alive. And then one of the most important and famous men during this period in the mid-1950s was Jackie Robinson, a hero to the black community. And he wrote a letter to Eisenhower regarding the Little Rock school integration. He said, "My dear Mr. President, I was sitting in the audience at the summit meeting of Negro leaders yesterday when you said we must have patience. On hearing you say this, I felt like standing up and saying, 'Oh no, not again.' I respectfully remind you, sir, that we have been the most patient of all people. When you said we must have self-respect, I wondered how we could have self-respect and remain patient, considering the treatment accorded us through the years. 17 million Negroes cannot do as you suggest and wait for the hearts of men to change. We want to enjoy now the rights that we feel are entitled to as Americans. This we cannot do unless we pursue aggressively goals which other Americans achieved over 150 years ago." 1957, the Southern Christian Leadership Conference was formed by Martin Luther King, Abernathy, Shuttleworth, Rustin. They wanted to challenge racism through nonviolent tactics. And these were the real heroes of the civil rights movement in the beginning. 1957, President Eisenhower signed the first civil rights legislation since Reconstruction about 80 years earlier. Now, it was a much washed down piece of legislation, but it was important that Lyndon Johnson was able to get at least something through the recalcitrant Senate. And this is when Strom Thurmond had the record-breaking filibuster in order to stop the legislation. And so that, for today, will be the end. But of course, this is only part of the story. We will continue the saga of Americans' original sin. In the next session, we take a look at more recent history and the protests and activities that have gone on, and to take a look towards the future when there need to be more protests and more action to restore. When I started my presentation, I told you that I would really appreciate it if you would hit the subscribe and the like buttons down below, because that gives me an incentive to produce more programs just for you.